What's your minimum specification?
Hi everyone, today you're watching the final video of my mini-series NDAs versus Embargoes. Today is video 6, Penalties and Problems. So to be clear, throughout this mini-series I should point out that I am not a lawyer. I have zero legal training. Anything I say in this video should not be construed as legal advice. If you need legal advice, consult a focused expert lawyer who deals with this stuff on a daily basis, not me. At no point do I pretend to be a lawyer, and in no circumstances should the content of any of these videos be used for legal purposes. This is an analysis based on experience and discussions with peers and other tech companies. If this disclaimer puts you off watching the video, I understand. Because I repeat, I am not a lawyer. You're free to watch any other video, but these are just my experiences. So what happens when you break an embargo or break an NDA? In earlier videos in this series, I've spoken about an attempt to generate legal relations. If you've got an NDA, it's literally signing a document. If it is embargo, it's a verbal or an email confirmation for yes. But in general, it's an attempt to create legal relations. The NDA may even state what court any action may be taken against you has to be in. And as somebody who signed the NDA, you would have to agree to that. So for Bay Area companies, it's usually California. Taiwanese companies, it's Taiwan. For Chinese companies, it's China. Now, I'm in the UK. I'm in none of those. But still, if I had to go defend myself, it would have to be in those courts. Though, say I wasn't able to defend myself and a default judgment was rendered against me, that may, in future, limit my access to those countries, to those states. I may be unable to obtain visas because I have a judgment against me, or I may have an imposed fine at a distance, so I can't actually enter the country or the state until the fine is settled. That makes it complex even of itself, and it may not be the individual. Some NDAs will specifically state the company is liable and not the individual. So if you're part of a big publisher, especially a publisher with presence in that state, or you deliver content to people within that state, within that country, then it can get very complex, very messy, and it could potentially be very expensive. Now, an embargo is kind of ambiguous on that. Even though it is an attempt to generate legal relations, it doesn't specify a state in which legal action could occur. But typically speaking, with an embargo, or even with an NDA, companies don't necessarily go down that legal route. And unless it actually pertains to a crime like disclosing financial information or confidential information relating to IP that could be used by a competitor, and then it just gets even more complex and even more messy. The most common effect of breaking an NDA is some form of blacklisting. By breaking an NDA, by breaking an embargo on purpose, you're essentially flipping the bird, giving the middle finger to that company. As a result, they're not likely to talk to you again. They're not going to agree to send you any review samples, give you any briefings, or invite you to any press events or disclosures again. Now, depending on the severity of the offense, it could be for a limited time or it could be permanently. For example, I know one media outlet that broke an embargo claiming that it got it from a different source. So even though it was technically, covered by the NDA, that company's result to that press was to not pre-brief them for 6 months on any new products coming out. So even though you technically didn't break an embargo or technically didn't break an NDA, if you skirt around that through different means, that company could have additional they could blacklist you for additional reasons, and they're at will to do that. They have no obligation to speak to anyone about any products. So you annoy them, you're at their whimsy. Now, there is a difference between annoying them and getting them to play fair, and some companies don't even want to play fair, and to which generally that's a screw you to the press, by which I respond by saying screw you company. But most companies are fair, but if you're not playing by the rules, they have every right to blacklist you or stop speaking to you or whatever. If a company truly wants to block all communication with you, it can be very difficult to start relations again, either as an individual or as a company, or even if the company's got new management, or even as the editor who caused the issue moves to a different publication. he might take his blacklist with them, but the blacklist still with the outlet may still exist. Once you get tainted like that, it can follow you for a long time. Now, even if you break NDA with one company, other companies in this industry might turn around and say, well, hey, this is a sort of guy who breaks NDAs. We're not going to deal with him. Why would we deal with them? Now, it may be that, okay, so you work for a big publication. They have to work with you in order to help get the information out. But using that as leverage is, again, a bit of a dick move. Some companies will acknowledge that there's an embargo break, but not actually do anything. Or there'll be a defined agreement between the two parties on how to work forward, as in they'll say to each other, you know, we will not brief you on upcoming products, just so you know, but, you know, feel free to write about them. And these sorts of things aren't really ever made public, so it's hard to determine exactly who gets blacklisted in what way without knowing the individual editors themselves and having a rapport with them to see what else is going on. So in a similar way, we can get to the point where these leak websites, these leak YouTube channels, where all they discuss is potential leaks, they could also be blacklisted just for the sake of perpetuating incorrect information, misinformation, or maybe getting something right that the company doesn't want to be known more widely. And yeah, we get to a situation where, again, the company can and has every right to not speak to people. And it's up to you whether you want to deal in that sort of information, whether you're under an NDA or not. Now, for the media that are caught up in this, like I say, the most common way of breaking an NDA is getting the time zone wrong. In general, depending on what sort of product is launched, that might be considered a minor infraction, and you might get a rap on the knuckles saying don't do it again, or double confirm next time, or we've even had companies writing to their NDAs, you cannot upload anything to the server until an hour before the embargo. That's a bit hard for that tech company to defend or even to detect. So we get into this issue of companies are worried about people breaking time zone NDA, and depending on, say it was a Zen 3 launch and somebody posted 3 hours early, you can tell that even if that was an accident, AMD is probably going to come down hard on that media outlet. Whereas if it's, say, you know, a new custom PC from a system integrator, the punishment may not be so harsh, or it may be you know, what have you. So recently we saw a popular YouTuber post their Comet Lake review 5 minutes early. In a private conversation, he said that he wasn't under NDA, or he got his sample elsewhere aside from Intel. You know, he was in the press briefings because he was there and people spoke to him. He basically said, he asked what the big deal was. 5 minutes early, it was only 5 minutes after all. But my issue there is, okay, it's 5 minutes early, right? You've posted 5 minutes early. You may not have been under NDA, but you knew when the embargo date was. So that's a big screw you to the rest of the media, okay? But you've posted 5 minutes. What's to stop somebody else posting 10 minutes early, or 15, or 20, or an hour, or a week? What the hell is an embargo, right? It just gets into silly season the minute media start playing with these vague slivers of time. Now, I've pointed out to companies when media, you know, are posting 5, 10, 15 minutes early, and I know some of them have been wrapped on the knuckles, or even worse, for, you know, being delayed samples for 3 months, 6 months. The fact that if you want to turn around and post 5 minutes early, that shows more about your character, about your desire to do that sort of thing, than it does about your content. And to be honest, I kind of feel sorry for you, right? Embargoes are a thing because people can't all be briefed at once. It gives everyone a level playing field. Otherwise, imagine a 100-meter race. Well, I'm going to start at 90 meters. Well, why can't I start at 80 meters? Why can't I start at 50 meters? It just becomes stupid. Right? What do I know? I'm just a talking head. Go ahead and keep doing it. Prove me wrong by changing your attitude. You know, sorry to end this series on a sour note. I have been wanting to make these series of videos for quite a while. I didn't realize how extensive I'll get into this, or how passionate I feel about it. There's a lot in this industry I really love, and there's some stuff that antagonizes me, and yeah, NDAs and embargoes, especially people who break them on, you know, such a small scale and then say, oh, what's the big deal? Yeah, it's most of the time it's pleasant and everybody adheres to anything. Everybody adheres to everything even. Yeah, and I enjoy that. I will state that, you know, I'm senior editor for AnandTech. I'm the senior CPU reviewer, and AnandTech has at times broken embargo on purpose, mostly before my time. The biggest example was perhaps Sandy Bridge back in 2011, 2010, where before Intel even briefed us on the products, Anand managed to get hold of a sample, and he posted a review of the microarchitecture with results 3 months early, 3 months before the product was due out. We didn't know at the time when the product was going to come out. We thought it was going to come out a lot earlier than that. But Anand went into detail about all the tests he was able to do, you know, and we didn't speak about where we got the CPU. I don't even know where we got the CPU, because this was a slightly bit before my time. But yeah, we broke embargo by 3 months. We spoke about the microarchitecture. We had deep discussions with Intel afterwards. We gave Intel a heads up, you know, to the point where they could form, you know, a legal response to us. It's sort of, you know, a right to reply sort of thing. But in the end, we did that. Yes, we got a lot of traffic, but because we weren't necessarily speaking about specific CPU products, when the review day came along, because it was Sandy Bridge, everybody got massive traffic. You know, and yes, I'm conflicted. On the one hand, you know, it was a break of it. We weren't technically under an embargo, but it was before, say, a disclosure date of the product. And, you know, as an AnandTech, we would do that sort of thing again. I mean, we're not going to post 5 minutes early, but if we were able to obtain information months in advance and be able to test, then yes, we would take advantage of that, because we know that's what our readers will want us to do, and we do it in a very AnandTech style way. What we wouldn't do is try and, you know, jip everybody else in the media by 1 or 2 days, because what would be the point? So that's my mini series on NDAs versus embargoes. Thank you for watching. If you stayed all this, again, I'll reiterate, I am not a lawyer, so don't take anything I've said as legal advice, please. I would like to hear your thoughts about this element of the industry perhaps you've never considered before, or if you are in the press, how you consider. Don't forget to like and subscribe. Like if you liked these series of videos. If you think I'm a complete tool and I have the wrong idea about this, well, you know where to get to me. I'm Twitter @IanCutris, or you can comment below and I'll respond to a few there. So thank you for watching, and what's your minimum specification?